Good evening, Fred and Karina, and welcome to our mediation session. The purpose of this mediation is to understand the issues from all sides so that we can identify common ground that may be present with a view to identifying early options for agreement. In order for this mediation to be successful, there are a number of ground rules that I need to go over. Firstly, we need to ensure that all parties have a chance to voice their concerns and issues, and that being the case, we need to, for the sake of the success of the mediation, allow the other party to speak unfettered when it is their turn. As I communicated during the preparation for this mediation, I will ask each party to make an opening statement to allow each party to see the dispute from the viewpoint of the other. From there, I will ask some questions of each side so that we can identify the issues and interests, and we should hopefully from there seek some common ground from which we can build some options for agreement. Please remember that the alternative to a successful mediation, which results in a settlement of this dispute, is of course the lengthy and costly litigation risk, and a risk which, as you've both identified, is something that you are not prepared to undertake unless absolutely necessary. Have we got any questions from this point?
No, not yet.
Nope.
Okay. Karina, would you like to go over the issues that you've encountered and why we've come to this mediation room today?
Yeah, definitely. So on September 23rd, 2015, I approached my boss, Fred, and requested that in the light of extra duties I had undertaken, that I be paid on the same level as my counterpart in the service department. To which party B responded, "You can't even do your job properly. If anything, I should be charging you for all the stuff-ups that you have made." Within 6 days of my initial request, I was presented with a warning letter for performance for an order that was incorrectly placed by myself. I was not given any warning to the letter to be given, nor was I offered a support person. I was not even given a chance to explain circumstances leading up to the mistake, which was I am on a large order. I believe that in that instance, that as the parts department manager was on annual leave, I had taken on their role, the new system, which we had little training on, making an error easy to do, and I completed over 9 hours of overtime that week. So I was exhausted and prone to making mistakes. None of this was documented or taken into account, but I did have the presence of mind to record that in my diary, as I felt I'd been railroaded and victimised. I've heard that my boss has had a problem with fat women, and I always got the feeling that he just didn't like me, and that this mistake was his chance to attempt to force me out of my job. I was asked to complete a large order just before 5 p.m. one Friday afternoon. I had previous plans, but I was told by my boss, Fred, that if I did not put this order through, I could forget turning up to work on Monday. Again, I felt intimidated, and this, I am sure, contributed to the error that I made, admittedly a large one. Following on this pattern of abuse, the day I was sacked, my boss marched into the staff room in front of all of my colleagues and completely humiliated me by shouting that I had cost him a fortune for the last time, while he threw my final termination letter on the desk that I could pack my bags and go. I had 15 minutes. I worked at ABC Parts and Services for 15 years. And the last two, which were owned by Fred, I never had an issue with the previous owners, yet Fred never appreciated the work that I did for him and unfairly dismissed me without giving me an opportunity to defend my work or my work ethic. I have agreed to try mediation as a way of reaching a settlement which covers the cost of lost wages and suffering that occurred as a result of my unfair dismissal.
Okay. And can I just clarify, you put in your submissions to me that you felt that settlement was $100,000. Is that right, Karina?
I believe it's $50,000.
$50,000. Okay.
Yes.
Can I just ask why you've arrived at the amount of $50,000, Karina?
Well, personally, I've got my living expenses that I need to take into consideration without any warning at all. This has come left field. I've got a mortgage, I've got 4 children, and a husband that's currently not working. And I just think for the time that I've spent within this business, 15 years, 50,000 it's not even enough. But in this situation, I would be happy.
Okay. And can I ask, did you come to that amount based upon any previous, any research that you've done and any previous similar settlements? What made you settle on 50,000? How do you quantify that in terms of the situation that we find ourselves in here? Where did you come up with that sum?
Okay, well, $50,000. I have talked to some lawyers and some other people that have been in similar situations to what I have, and just cost of livings is quite expensive. We are in the year 2016, so it's definitely not cheap to raise 4 children, and the effort and time that I've put into this company over 15 years to just be, not even take it into consideration. So I have had some support from peers and colleagues and family, and also legal advice on this amount.
Okay, fantastic. Fred, can I hand the floor over to you? Can you run through your opening statement, please?
Well, yes, Tammy, I would like to say that I feel I'm subject to opportunistic litigation to start off with.
Mm-hmm.
In addition to this is that just listening to Karina saying that she's worked there for 15 years, I've also led to believe that since we've taken over, Karina, in this anecdotal evidence that, Karina has eroded morale and team morale based on the fact that she's had a great relationship with the previous owners. Hence the fact that they've overseen or overlooked numerous performance-based issues. So where we are today has a result of previous experience and previous, obviously, scenarios that has unfolded. So based on that, so that's my opening statement. So moving forward, I feel obviously as an employer, someone with 15 years experience in a role and has taken up 9 hours of overtime, there's obviously enough evidence to prove that she's worked far more overtime in the past without any real problems. So all of a sudden 9 hours, which is roughly 1.5 hours a day, cannot make you that tired that you make huge mistakes, which I feel was just basically negligence. And again, as an employer, I expect that my employees are careful and they perform their duties according to their job descriptions. And obviously, we are in a business where costly errors can actually result in a huge impact on the business and the viability of the business from a sustainability perspective. And an inspection of our accounts revealed that Korea was making consistent errors. So it's not even that it's only an error as of late with the overtime where she claimed she was tired. So this is coming over a period of time, and there's also been numerous written warnings given to her for the lack of attention to detail. An inspection of our HR records show that Karina had never been subject to any formal performance management in the past. And hence the fact with my opening statement, the friendship that she has gained with the previous owners have allowed her to kind of get away with that sort of behavior, and also not paying attention to detail, as I said before, and not performing a role with diligence. And then further, I followed the procedure, provided a requisite amount of written warnings, and one which was note was for mistake of an estimate of $10,000. And again, as you can understand, that is a significant amount of dollars for a small business to pay. And as far as I'm concerned, regardless of the length of Karina's tenure with the business, I personally feel that as an employer, I've got a right to performance management of my staff and manage the staff accordingly to not only safeguard the rest of the employees, but also the business.
Okay. All right. At this stage, could I just ask if I could just speak to Karina? Could I just speak to you just on your own, just for a little bit, just have a quick private session? So Karina, Would I be right in saying that there's a theme here that you're feeling, especially in light of Fred's revelation that you hadn't undergone any type of performance management, regardless of whether it's warranted or not, that there's this constant theme that you felt intimidated and harassed. It was a new experience for you?
Definitely, and I performed very well with the old owners of the business, and Fred did make a lot of changes within the business, hiring and firing a lot of staff. There was a lot of new staff within the business now, and I did hear along the grapevine at my work that he didn't like fat women, and I found that he was hiring a lot of sexy women, and I just kind of felt on the outskirts. And I do truly believe that it's not my work. It's got a lot to do with my appearance, and I just don't fit into his criteria of his perfect corporate world in his business.
Okay, so you were feeling undervalued in the business, and you felt under pressure. If we could come to a settlement that recognises that you as a person were valued, it was just the performance, that if you could recognise that formally in a way that would allow you to seek future employment unfettered, would that be something that you would be willing to look at as part of a settlement agreement?
I'm not going to say yes, and I'm not going to say no. It's definitely taken a hit on me personally as a person and my confidence. And I guess if it, under the right situation and the right circumstances, I would be willing to have a look at something. But as I said, it has not been approached in a ethical manner by any means. If I'm not doing the right thing, then support me with some training and help me and show me where I'm doing wrong, instead of yelling at me and hearing that I'm just a fat, lazy person that can't do my job properly.
Sure. Okay. Understanding that, I guess as humans we do tend to have a very adversarial way of approaching negotiation. But I think if we could take the personality out of things and just focus on the problems here, what we might be able to do is come up with a solution. Would I be right in saying that obviously with your financial and family commitments, having having an experience such as you've just had, if you could come up with something that, if we could come with a settlement that maybe provided you more training so that you could re-enter the workforce sooner, maybe even if that was provided in a way whilst there might have been performance issues, perhaps recognise that you as a person, were a valued person. It was just he's clearly seen some performance issues that he didn't fit with his business model. If that was recognised, so that the sacking on your CV wasn't as much as as a hindrance to your future employment as you may feel, perhaps the writing of a reference that enhances the positive aspects of your performance, and I'm sure there were many, would that be something? And just to remind you, Karina, that litigation is very risky, and if you lose, you can bear the costs of that, and it can be a very lengthy process. So the time that you may spend embroiled in litigation, you could be out there looking for fruitful employment, and then there are also all of the other stigmas that do come with this type of litigation in the workplace. So if we were able to get you into the workplace faster with some tools, perhaps Fred could maybe talk about some training courses that would assist you, and some positive references that focus on the positive aspects, and an undertaking to be, whilst not having to lie about your performance, perhaps be as positive as you can, and focus on the positive attributes that you did show during your employment, should he be contacted for a reference. Would that be something that you'd be amenable to, Karina?
Definitely, and I guess the big part in me now having a look for a new job with that the sacking on my CV, as you mentioned and we have discussed. I do believe that if they were able to call him in and give me a positive reference, that would definitely assist. And I do understand time is money, and I'd prefer to be out looking for a job and bringing that income back to my family. But I still feel as though there's a dollar value that needs to be attached to this as well.
Okay, fantastic, Karina. Well, at least I'll have a chat to Fred separately and see if there's some way we can work towards that kind of if we can establish a common ground there. Because I understand your position that you want 50,000, but I think the interest lies in your ability to earn an income. So let's see if we can find some common ground there. I'll just call Fred and see if I can, pardon me, go into the private session with him and see if I can.
All right, excellent.
Fred, thank you for your time today. Look, I guess from my view, what I'm seeing is that you want the freedom as an employer to run the culture of your business and the processes in your business as you see fit. Would that be a fair assumption?
Correct.
Okay. Obviously, your position is you don't want to be the subject of opportunistic litigation, but I think we've both established that we also, especially with yourself being a small business, don't want to be embroiled in a long-term litigation that could bear, depending on the circumstances, it could not bear in your favour. Would that be correct?
Correct, Tammy, but that's, the scenario with that is obviously that as a business, we do plan for those sort of things, especially with employing people, based on the fact that I think we've got ample evidence proving that someone with 15 years experience in exactly the same role can make blunders like that that's costing the company thousands. And in fact, based on some of the records and stuff, we actually have recourse on trying to recoup some of that money privately from it as well. So even subject to this, I do have the right to try and recover that other money due to negligence. And
I understand that, but I also understand that obviously if we can come out of this where we can put it behind us, and Karina can move on in her future with different employment, obviously I understand that. I think essentially your interest lies in having the freedom to, within the confines of the law, run your business as you see fit, without feeling that you may be beholden to vexatious or opportunistic litigation. Would that be right?
Well, yeah, again, and as I said before, as a business, we do plan for these contingencies. And, should we go down we don't want to go down the path, but in this case, specifically based on Karina's history and experience, and also the losses the company has incurred, I think we've got, actually, there's two separate cases here, because we will try, should this go further litigation, we will also try and also recover the monies from via other avenues. Again, as I said, we've got anecdotal evidence that Karina has eroded morale. We've got numerous other written warnings in the past 2 years that's been given to her for exactly the thing about negligence and attention to detail, and so forth. So from our perspective at this stage, I think we're happy to go either way. Based on the fact that we believe we've got enough evidence to prove that she has not performed according to her position description.
Okay, I understand that. Being that obviously you put some money aside for instances such as this, I think where Karina is coming from is a position of financial security. Would you be amenable to a settlement where we perhaps not talk about lump sum money, but talk about perhaps providing a reference, if it was possible, that highlighted her positive attributes and perhaps enrolled her in a further education course of a limited value, maybe $2,000 or $3,000 or $4,000 course that would enable her to continue to gain further employment, maybe address some of the issues that you saw and prevent you from entering into litigation. And perhaps there would be perhaps some reputational benefits for you as a small business in a regional area. Would that be something that...
Well, for one, should I consider that, I would not give Karina a reference until I would be satisfied that she's trained adequately, because she would put anyone else's business at risk. And as a business owner, I would be deemed not doing the right thing. So should I do continue down that path, I will have to be clear that she will have to complete training courses first before and see the evidence that she has completed it, as we know that she has a lack of attention to detail. Otherwise, I will not give you any reference. I refuse to do it, as I would damage someone else's business. And I think I've got a duty of care to prevent that.
Okay. Well, I think we can now maybe pop back in the room together and table these options.
Okay, not a problem.
So, Karina and Fred, thank you once again for joining us in the room. I think we've made some headway. What I would like to do is maybe table submission, some options, and reschedule a meeting to discuss these further. There is the option on the table, Fred and Karina, that we could provide Karina yourself. Fred could provide you with some training, further to the point where he would be satisfied that the issues that arose in your performance that were the catalyst for the warning letters and the performance management on his side were addressed. And should you be successful in this particular training course, then he would be more than happy to provide a reference. Would that be a correct summation of an option that you'd be happy with, Fred?
Yes, absolutely.
Okay. Karina, Fred has, in his company, his service and parts company, as you may or may not be aware, does have insurance to cover any litigation costs, and he has got quite a lot of documentation that may work against your favour. So perhaps you want to take those facts that we've outlined today, go and have some time to think about them, and we will reconvene. I will send out a diary meeting for you to attend another meeting, perhaps in 1 or 2 weeks, so that we can see if we can come to a settlement that you're both agreeable to. Okay, so thank you both so much for attending today's meeting, and I will send out that meeting request for the further discussing of settlement at a later time.
Fantastic.
Thank you.
Thank you.
For your time.